Okay, this is your jury charge performance challenge for week number 4. Paragraph. Members of the jury, comma, I want to thank you for your patience and the attention you have given to this particular case, period. You, comma, as jurors, comma, are the judges of the facts, period. But in determining what actually happened in this case, dash, that is, comma, in reaching your decision as to the facts, dash, it is your sworn duty to follow the law I am now in the process of defining for you, period. Unless otherwise stated, comma, you should consider each instruction to apply separately and individually to each defendant on trial, period, paragraph. And you must follow all of my instructions as a whole, period. You have no right to disregard or give special attention to any one instruction, comma, or to question the wisdom or correctness of any rule I may state to you, period. That is, comma, you must not substitute or follow your own notion or opinion as to what the law is or ought to be, period. It is your duty to apply the law as I give it to you, regardless of the consequences, period, paragraph. By the same token, it is also your duty to base your verdict solely upon the testimony and evidence in the case, comma, without prejudice or sympathy, period. That was the promise you made and the oath you took before being accepted by the parties as jurors in this case, comma, and they have a right to expect nothing less, period, paragraph. So, comma, while you should consider only the evidence in the case, comma, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience, period. In other words, comma, you may make deductions and reach conclusions, comma, which reason and common sense lead you to draw from the facts, comma, which have been established by the testimony and evidence in the case, period, paragraph. You may also consider either direct or circumstantial evidence, period. Direct evidence is the testimony of one who asserts actual knowledge of a fact, comma, such as an eyewitness, period. Circumstantial evidence is proof of a chain of facts and circumstances indicating either the guilt or innocence of the defendant, period. The law makes no distinction between the weight to be given to either type of evidence, period. It requires only that you weigh all of the evidence and be convinced of the guilt of the defendant beyond a reasonable doubt before he can be convicted, period, paragraph. Now, comma, I have said that you must consider all of the evidence, period. This does not mean, comma, however, comma, that you must accept all of the evidence as true or accurate, period, paragraph. You are the sole judges of the credibility or believability of each witness and the weight to be given to his testimony, period. In weighing the testimony of a witness You should consider his relationship to either side of the case, semicolon, his interest, comma, if any, comma, in the outcome of the case, semicolon, his manner of testifying, semicolon, his opportunity to see or know about the things he says, semicolon, his candor, comma, fairness and intelligence, semicolon, and the extent to which he has been supported or contradicted by other credible evidence, period. You may, comma, in short, comma, accept or reject the testimony of any witness in whole or in part, period. Also, comma, the weight of the evidence is not to be determined by the number of witnesses who have testified on either side, period. You may find that the testimony of a smaller group may be more credible than the testimony of a larger group, period, paragraph. A witness may be discredited or impeached by giving contradictory evidence, comma, by showing that he testified falsely about something that was very important, comma, or by evidence that at some other time the witness has said or done something, comma, or has failed to say or do something which would conflict with his present testimony, period, paragraph. If you believe that a witness has done this, comma, then it is in your power to give the testimony of that witness such credibility or weight, comma, if any, comma, as you think that it deserves, period, paragraph. As I told you before, comma, a defendant has the right not to testify if he so desires, period. If a defendant does testify, however, his testimony should be weighed and considered, comma, and his credibility determined, comma, in the same way as that of other witnesses, period, paragraph. The testimony of a person who says he was an accomplice, comma, and the testimony of one who provides evidence against a defendant as an informer for pay or for immunity from punishment or for some other personal advantage, comma, must always be examined and weighed by the jury with greater care and caution than the testimony of an ordinary witness, period. You, the jury, comma, must decide whether the testimony of such a witness has been affected by any of those circumstances, comma, or by his interest in the outcome of a case, comma, or by prejudice against the defendant, period. You need to look at whether or not he will benefit in a financial way because he has testified against the defendant, period. If you should find that the testimony of such a witness was affected by any one or more of those factors, comma, you should keep in mind that such testimony is always to be received with caution and weighed with great care, period, paragraph. You should never convict any defendant upon the unsupported testimony of such a witness unless you believe that testimony beyond a reasonable doubt, period, paragraph. If the defendant has offered testimony that says he has a good reputation and is a person in good standing in the community, comma, you should consider that carefully, period. Also look at whether the testimony says that he is an honest, truthful person, period. You need to know if he is a good person, period, paragraph. If you find that his reputation is in direct conflict with the crime with which he is charged, comma, you may consider that this may give rise to reasonable doubt, period. You may think, comma, as a jury, comma, that it is very unlikely that a person of such good character in respect to those traits would commit such a crime, period, paragraph. The jury will always bear in mind, comma, however, comma, that the law never imposes upon a defendant in a criminal case the burden or duty of calling any witness or producing any evidence, period, paragraph. Now it is time for you to go to the jury room to deliberate and return a verdict, comma, if you can do so, period.